Hello, everybody. Welcome to the 2018 Scalia Lecture, Liberal Education, Law, and Liberal Democracy by Peter Berkowitz. Let me start, as is the custom, by saying a few words about the lecture, the namesake, and the person who is here to deliver it today. The Justice Antonin Scalia Lecture is a lecture series established at the Harvard Law School in 2013 by an anonymous donor. The purpose of the lecture is to promote and advance understanding of the founding principles and core doctrines of the United States Constitution. Our speakers are drawn from the fields of political science, history, philosophy, law, government, religion, and related disciplines. The person chosen to be a Scalia lecturer is a scholar of or figure of high distinction who, through his or her work, research, writings, and teachings, elucidates the principles of the American founding. This lecture will be held annually for at least 10 years. And I want to start by thanking the selection committee, Marianne Glendon and Jack Goldsmith, for their work in selecting the Scalia lecture this year. Let me also take a moment to acknowledge the Scalia family and to thank them for joining here. Here in the audience are Mrs. Maureen Scalia, the Justice's son, Gene Scalia, and his grandson, Will Courtney. We're delighted that you can all be here. I want to say it's very meaningful for me to convene the Scalia lecture. Justice Scalia was, of course, a very deeply influential justice who changed the way lawyers and judges think and reason about statutes and the Constitution. His colleague and friend, Justice Kagan, wrote last year, quote, "Does anyone now ignore the founders' commitments when addressing constitutional meaning, or just as important, dispute the need for a viable theory of constitutional interpretation, even if not Justice Scalia's brand of originalism, to constrain judges from acting on their personal policy preferences?" Let me also add a personal note. I was a law clerk to Justice Scalia early in his time on the court. He was a warm, generous friend and teacher to me. He was also very generous to our students during his many visits to Harvard Law School. When he came to HLS, as I'm sure was true at many other law schools, so how can I put this? Not every person who asked him a question agreed with him. In fact, he got hard questions from the left and sometimes even from the right. And what's important is this. He handled these hard questions with humor, openness, and humility. He knew that disagreement, and sometimes profound disagreement, is integral to the job of being a lawyer. And he famously said, "If you take it personally, you're in the wrong line of work." The generosity and collegiality he modeled in his trips to his alma mater meant so much to me, to the faculty, and to our students. Okay, and now our speaker. So without further delay, I'm delighted to introduce Peter Berkowitz. I want to start by thanking Dr. Berkowitz. He was scheduled to be the Scalia lecturer last year, and he very kindly agreed to let me stand in for him after the justice passed away. And I say this in part because I want to note that I had told Justice Scalia that we planned to invite Dr. Berkowitz, and the justice wholeheartedly approved of the choice. So I thought that was worth mentioning. Dr. Berkowitz is the Tad and Dianne Taube Senior Fellow at the Hoover Institution at Stanford. He's the author of many books. He's the editor of 7 collections of essays, and he has written hundreds of articles, essays, and reviews on a range of topics for a wide variety of publications. He is the 2017 recipient of the Bradley Prize. He holds a JD and a PhD in political science from Yale, an MA in philosophy from Hebrew University, and a BA in English literature from Swarthmore College. Without further delay, it's my great pleasure to give you Dr. Peter Berkowitz.
Thanks very much, Dean Manning, for a generous introduction and moderating the event. I also want to thank your predecessor, Dean Martha Minow, who extended the original invitation. And I want to thank members of the committee, Jack Goldsmith and Mary Ann Glendon. Grateful for this opportunity to share some thoughts on liberal education, legal education, and liberal democracy. In drawing out some connections among them, I follow John Stuart Mill. Mill took up the topic of liberal education in February 1867 in a magnificent and all but forgotten speech, rectoral address that he delivered at the University of St. Andrews. Mill emphasized the distinction between liberal education and professional education. Professional education prepares you for remunerative work. Liberal education develops, I quote, capable and cultivated human beings. Capable and cultivated for what? For freedom, for flourishing as free persons, for self-government, both in the sense of governing oneself and in joining in the governing of the country. According to Mill, liberal education furnishes and refines the mind. It furnishes the mind with history and literature, with science, with economics and politics, with morality, religion, and philosophy. It refines the mind by teaching students to appreciate the complexities of critical issues and to see the several sides of hard questions of morals and politics. In furnishing and refining the mind, liberal education tends to temper judgment and elevate character. Though different from professional education, liberal education enables professionals, lawyers, and other professionals to practice their professions more effectively, more wisely. As Mill observed, I quote, "Men may be competent lawyers without general education, but it depends on general education to make them philosophic lawyers who demand and are capable of apprehending principles instead of merely cramming their memory with details." Now, some may suppose that nothing could be more anathema to Justice Scalia and his originalist jurisprudence than, quote, philosophic lawyers. To the contrary. True, Scalia was a blistering critic of resorting to moral and political theory in deciding hard questions of constitutional law. But his criticism of the living Constitution, of the moral reading of the Constitution, stemmed from serious study of the history of Anglo-American jurisprudence and theories of the proper role of courts in a liberal democracy. My point for now is not that Scalia was right about originalism. Instead, I want to emphasize that the quarrel between originalism and the living Constitution turns on just the sorts of learning and just the sorts of thinking, the thoughtfulness at the heart of liberal education. In the summer of 2015, I had the opportunity to see Justice Scalia's, let's call it, judicial pedagogy in action. I accompanied 25 or so talented undergraduates to the Supreme Court to meet with him. These undergraduates had come to Washington for the summer to study political philosophy, the American political tradition, and domestic and foreign policy. At the beginning of our hour together, Justice Scalia stood scowling next to a small lectern. His arms were crossed, his brow was furrowed. He really did not seem pleased to be with us. And he began with a grim hypothetical. Some of you may have heard this before. He said, if by some terrible misfortune I should be forced to leave the United States of America and find a new country in which to live, I wouldn't search for a country with a Bill of Rights. That, you see, before I was a judge, I was a professor of law, and I had occasion to study comparative constitutional law, including bills of rights. I even studied the Soviet Union's Bill of Rights. It was long and beautiful, abounding in inspiring promises. those promises, Justice Scalia said to the students, no doubt you already understand this from your study of history, those promises were worthless. Justice Scalia fell silent. Justice Scalia continued, were I to be exiled from my beloved United States of America, I wouldn't search for a Bill of Rights, but I would search for a country with well-designed political institutions, so that powers were dispersed and blended among the branches of government which operated to check and balance one another. Because history teaches, and the study of government shows, that the separation of powers is the best means for thwarting those abuses of power and invasions of liberty to which people who hold political office have been forever prone. Justice Scalia fell silent. He looked around at the faces of the students. He could see that he had unsettled them, discomfited them by elevating the separation of powers above the Bill of Rights. And as he looked at the students' faces, you could see the first signs of pleasure on his face. He invited questions. As the questions grew bolder, Justice Scalia grew more at ease. One student asked, Justice Scalia, how come you write such harsh dissents? Can you really expect your rhetoric to persuade your colleagues? He chuckled, said, no, I can't expect my dissents to persuade my colleagues. Indeed, if I'm writing a dissent, it means that I've already failed to persuade a majority of them. I write my dissents the way I do, lively, hard-hitting, I suppose some would say acerbic, for the sake of students, for young men and women like you, to wake you up, to grab your attention, to provoke you to think. Rising to the provocation, one student asked Justice Scalia whether he could name even a single case in which his vaunted judicial philosophy yielded a result that conflicted with his political preferences. Scalia loved it. Sure, that's easy, he said with a certain swagger. I could name dozens. I suppose the most dramatic was a 1989 case, Texas v. Johnson, the flag-burning case. He paused for a moment, clasped his hands, pursed his lips, thought, and then he continued quite merrily. Let me tell you something. In the kingdom of Scalia, flag burning would be banned. But I don't live in the kingdom of Scalia. I'm a citizen of the United States. I serve as a justice on the United States Supreme Court. My job, my solemn duty, is to determine what the Constitution requires, permits, prohibits. Study of the First Amendment's original meaning reveals that the Constitution provides broad protection to speech, especially political speech, very much including opinions that I detest. This broad protection includes something that my court calls expressive conduct. For example, burning a flag, that's conduct. That expresses a political opinion. To be sure, a political opinion I find reprehensible, but a political opinion nonetheless. Accordingly, I cast my court's fifth vote to uphold the right of U.S. citizens to desecrate the American flag. Mind you, Justice Scalia added, I did so at some personal cost, he told the students. You see, Justice Scalia went on, in the Scalia household, Mrs. Scalia stands watch over the right-wing flank of the Scalia family. For weeks after my decision, as Mrs. Scalia made breakfast, she would hum, rather aggressively, the battle hymn of the Republic. Now, I recount these highlights, some of the highlights of Justice Scalia's conversation with the students, not only because they provide entertaining and I think instructive glimpses of the man, they also illustrate the importance to legal education of liberal education. to understand the Constitution. We must study not only cases and jurisprudence, but history, political theory, competing political traditions, and much more. Unfortunately, today, liberal education is in bad shape. It's exposed to three principal threats. Free speech has been attacked and curtailed. Due process has been denigrated and diluted, and the curriculum has been hollowed and politicized. These are not isolated and independent threats. They're interconnected. All three are rooted in the conceit of infallibility. To remedy one requires progress in remedying all three. Consider free speech. From speech codes and trigger warnings and microaggressions and safe spaces to disinviting speakers and shouting down lecturers, free speech has been under assault for some time. Speech codes go back to the late 1980s. One reason now why this has continued is that as polls by Gallup and others show, undergraduates today, many undergraduates today, really don't know what is in the First Amendment. And when they are informed that the First Amendment protects offensive and even hateful speech, they don't like it. Why has free speech fallen out of favor? Many students, faculty, and administrators suppose that there's a fundamental conflict between free speech and the undoubted good of diversity and inclusion. More speech, so the argument goes, causes pain and suffering for marginalized students. This way of thinking about the matter, I think, stems from a faulty understanding of free speech, of diversity and inclusion in education, or of both. Yes, words wound. Most children learn this from the beginning and from experience. History teaches, however, that beyond true threats, direct and immediate incitement to violence, defamation, sexual harassment, other narrow exceptions, that beyond these, the costs of regulating free speech greatly exceed the benefits. One cost is that regulating speech disposes majorities to ban unpopular opinions and to see opinions with which they disagree as unpopular. Well-meaning people say, I hear you, I'm with you, I support free speech. But what does free speech have to offer historically discriminated against minorities and women? The short answer is a great deal, knowledge and truth. The long answer begins with three observations. First, for many years, women have actually formed a majority in higher education. Approximately 56% of students at American universities are female. On any given campus, women plus historically discriminated against minorities, likely represent a large majority on campus. Thus, the curtailing of campus speech on behalf of historically discriminated against minorities and women actually reflects the will of a new campus majority. And sadly, this new majority exhibits the same old antipathy to free speech. The new majority traffics in the same old repression of offensive speech. This new majority succumbs to the same old temptation to police speech that has been the bane of democracy. Second, far from serving as an instrument of oppression, as a tool of white male privilege, free speech has always been a weapon of the weak, on the side of persecuted minorities, dissenters, iconoclasts, and reformers. In the United States, free speech was essential to abolition, women's suffrage, the civil rights movement, feminism, gay rights, transgender rights. All took advantage of the room that free speech creates to criticize and correct the established order. Restricting speech, that is censorship, has been from time immemorial a weapon of authoritarians. Third, a campus that upholds free speech and promotes its exercise is by its nature diverse and inclusive. Such a campus offers to everyone, regardless of race, class, or gender, marvelous benefits. It provides the opportunity to express one's opinions with all the evidence and arguments at one's disposal, even with bad evidence and bad arguments. It provides the opportunity to listen to a variety of voices, some bound to complement one's view, some sure to conflict with one view. And not least, such a campus provides the opportunity to live in a special kind of community, a community devoted to intellectual exploration and the pursuit of truth. Instead of touting free speech's benefits, however, at many campuses around the country, schools seem to encourage students, especially, but not only, historically discriminated against minorities and women, to see themselves as somehow unfit for free speech, to see themselves as weak and wounded, frail and vulnerable, subjugated by invisible but pervasive social and political forces. Standing liberal education on its head, colleges and universities enlist students in cracking down on free speech. Liberal education ought to cultivate curiosity and skepticism. It ought to cultivate conscientiousness and boldness in fashioning arguments. It ought to cultivate civility in speaking, attentiveness in listening, and coolness and clarity in responding to provocations. These virtues enable students, regardless of race, class, or gender, to take full advantage of the benefits of free speech. In his masterwork, On Liberty, Mill provides a nifty guide to the advantages that derive from the broadest possible protection of free speech, regardless of the status of your opinions or the status of the other person's opinions. There are three possibilities, Mill writes. The first possibility is that your opinion is false. Sometimes happens. In that event, you clearly benefit from free speech because it provides access to true or truer opinions. The second possibility, perish the thought, but it happens, is that, the first possibility is that your opinion is false. The second possibility is that your opinion is true. But even there, you benefit, and benefit mightily, from free speech. Why? Because unless we are compelled to defend our true opinions, they grow stale. If untried and untested, if accepted on faith and affirmed reflexively by all around us, we lose sight of our true opinions' foundations, implications, and limitations. If our opinions are true, we profit from free speech because the encounter with error, the other person's error, invigorates our appreciation of the reach and roots of our opinions. But the third possibility is the common possibility. Typically, our opinions are a mixture of true and false. So are the other person's opinions a mixture of true and false. Free speech fosters the give and take that enables us to sift out what is false in our views and to discover what is true in the other person's views. How can colleges and universities reinvigorate free speech? Here are a few suggestions. Abolish all speech codes and all other forms of censorship. Publish a formal statement on the university's website affirming the advantages of free speech. 3, incorporate into freshman orientation seminars on the importance of free speech. 4th, punish those who shut down speech or otherwise disrupt it. 5th, host an annual lecture on the theory and practice of free speech. 6, publish an annual statement about the condition of free speech on campus. And 7, and this is very hard, where possible, and it's not always possible or desirable, but where possible, strive for institutional neutrality on partisan controversies. The better to serve as an arena for vigorous controversy, for vigorous debate about enduring controversies. Many colleges and universities, the last couple of decades have shown, won't act on their own. States should consider enacting legislation, including measures like those I've just outlined, to assist public universities, which actually are subject to the First Amendment, to comply with their constitutional obligations. Private universities are not subject to the First Amendment. But like public universities, private universities have a surpassing educational interest in safeguarding free speech. To help private universities discharge their educational responsibilities, more should follow the lead of California. Through the Leonard Law, California prohibits private universities from restricting speech, from restricting constitutionally protected speech. Perhaps Congress should also consider tying federal funding to willingness to protect speech. The curtailing of free speech on campus has not occurred in a vacuum. It is closely connected to the denial of due process and disciplinary hearings dealing with allegations of sexual misconduct. Both the curtailing of free speech and the denial of due process suppose that little is to be gained from listening to the other side. Both rest on the conceit of infallibility. For example, common campus practices presume guilt by referring to accusers as victims and the accused as perpetrators. Universities have deprived the accused of full access to the charges and evidence and of counsel. Schools use the lowest standard of proof, a preponderance of the evidence, despite the gravity of allegations. They deny the accused or counsel the right to cross-examine witnesses, even indirectly. And they allow unsuccessful complainants to appeal, effectively exposing the accused to double jeopardy. To achieve their preferred outcomes in disciplinary procedures and grievance hearings, universities have even been known to flout their own published rules and regulations. Please don't misunderstand. There is no room for sexual harassment. Predators must be stopped. Sexual assault is a heinous crime. Universities should provide complainants immediate medical care and, where appropriate, psychological counseling and educational accommodations. Those who are found guilty should be punished to the full extent of the law. At the same time, schools must honor due process, which rightly embodies the recognition that implementing justice is always the work of fallible human beings. Some would nevertheless truncate due process on the grounds that a rape epidemic plagues higher education. Fortunately, it is not so. Yes, even one incident of sexual assault is too many. Yes, women's safety is a priority. Yes, more can be done. But according to Department of Justice statistics, and contrary to the conventional campus wisdom, university women confront a lower incidence of sexual assault on campus than women off campuses. Others would curb due process because all women should just be believed. For sure, all women should be heard. All women should be heard. But they shouldn't just be believed. especially where another's rights are at stake. And for a simple reason: women too are human beings. And science, the science of memory, has amply confirmed that because of our human imperfections, we human beings routinely forget. We human beings routinely remember things that never were, and we human beings routinely reconstruct the past in ways that serve our passions and interests. Then there's the question of why universities are involved at all in allegations of non-consensual sex. That, after all, is a statutory definition of rape. And in general, violent crimes are left to the police and the courts. If a student were accused of murdering another student, who would dream of convening a committee of administrators, faculty, and students to investigate, prosecute, judge, and punish? And to take something much lesser, if a student were accused of stealing another student's car or vandalizing it, would we turn to a university committee for justice? If in case of the gravest crime, murder, and a much less grave crime, theft, vandalism, we don't turn to the universities, we turn to the police and the courts. Why, in connection to the violent crime of rape, do we turn to universities? After all, administrators, faculty, and students generally lack training in collecting and analyzing evidence, in questioning witnesses, in presiding over hearings. Why then suppose that they are qualified to investigate, prosecute, judge, and punish alleged criminal conduct that carries sentences of years in jail? Why? Partly because the government said so. In April 2011, the Department of Education's Office for Civil Rights issued a Dear Colleague letter. The Dear Colleague letter reinterpreted universities' obligations under Title IX. Title IX prohibits universities that receive federal funding from discriminating on the basis of sex. That prohibition is good. But OCR in April 2011 equated due process for men with discrimination against women. That's bad. And OCR threatened universities with costly federal investigations and the loss of federal funding if they did not reduce drastically due process for those accused of sexual misconduct. That reduction of due process was bad. In fact, the Obama administration was pushing on an open door. Administrators, professors, and students have internalized doctrines, first developed more than 30 years ago by law professor Catherine MacKinnon. In Toward a Feminist Theory of the State, MacKinnon argued that in a, I quote, male supremacist, close quote, society like ours, women may not be able to distinguish sex from sexual assault. It follows that women are unable to give meaningful consent. Just 2 months ago, Jessica Bennett, the New York Times New Gender editor, suggested in an op-ed that, quote, cultural expectations render some women, quote, unable to consent. That is, cultural expectations force women, against their will, to consent to sex. Emergency conditions justify emergency measures. The theory that women are a systematically subjugated class motivates the suspension of due process. It impels universities to impose on men the responsibility to obtain affirmative consent. Yes means yes at every step of sexual relations. But this theory entails that yes may not be enough. For campus authorities may always interpret a yes as wrongfully extracted by the oppressor's, quote, emotional coercion or, quote, emotional manipulation of the oppressed. And we have cases where that is so. Now, the denial of female agency implies that a man who acknowledges sex with a woman has prima facie committed sexual assault when you deny female agency, since women on this theory are incapable of giving real consent. This approach, all too common on campuses, may be illegal, insofar as it presumes male guilt and denies men due process. It appears to violate Title IX by discriminating against men on the basis of sex. But that's a legal argument. This view, it seems to me, is also profoundly illiberal. It's contrary to the spirit of democracy. It rejects an assumption of our liberal democracy, which is that women are free and equal, that women are able to make their own decisions, that women are responsible for their actions. The willingness of university officials to presume guilt and dispense with due process can be seen in the more than 150 cases wending their way through state and federal courts since 2011, alleging unlawful deprivations of due process and disciplinary hearings dealing with sexual misconduct. Lawsuits arising from Amherst, Berkeley, Oberlin, Swarthmore, USC, Yale, and many, many more make chilling reading. Several victories for plaintiffs have already been recorded. Serious as the problem of sexual misconduct is, much as we must struggle to combat sexual misconduct, there is no legitimate justification for denying due process. The cornerstone of legal justice in liberal democracies. There's no justification for denying it in campus cases dealing with sexual wrongdoing. The denial of due process actually causes harms that go beyond those suffered by those wrongly convicted. The denial of due process on campus actually undermines liberal education. By jettisoning the distilled wisdom about fundamental fairness in a free society, higher education accustoms students to the exercise of arbitrary power. It habituates students to regard established authority as infallible. What should be done? Last fall, the Department of Education took an important step by rescinding the OCR's April 2000 Dear Colleagues letter. The federal government no longer mandates the denial of due process on campuses in disciplinary hearings regarding sexual misconduct, but it doesn't require due process either. To take advantage of their new freedom, universities should consult the exemplary 2014 statement published by 28 Harvard law professors in the Boston Globe. All should consult it. The statement offers guidance in reconciling the struggle against sexual misconduct with the imperatives of due process. Universities should inform students in a timely fashion of the precise charges against them and of the facts alleged. They should ensure that accused students have adequate representation. They must adopt a standard of proof and other procedural protections commensurate with the gravity of the charge. This includes the right to cross-examine witnesses, if indirectly, and the opportunity to present a full defense at an adversarial hearing. No one office, particularly the Title IX office, which is an interested party, should be assigned responsibility for fact-finding, prosecuting, adjudicating, and punishing. In addition, universities, as I said, should include sessions on due process and freshman orientation. It is unreasonable, however, to expect the restoration of due process on campuses around the country anytime soon. For starters, that restoration depends on reinvigoration of free speech. A culture of free speech presupposes and promotes a healthy sense of fallibility. That opens one to the justice of due process. For what is due process but the formalization of the efforts by fallible human beings to evaluate fairly other fallible human beings' conflicting claims? More free speech, however, is not enough to rehabilitate due process. Commitment to both is rooted in an understanding of their indispensable role, that is, the indispensable role of free speech and due process in liberal democracies. To recover that understanding, the understanding of the role of free speech and due process in liberal democracies, it'll be necessary to renovate the curriculum. The college curriculum, and this has been true for a long time, has been hollowed and politicized. The conceit of infallibility is again at work. In the conceit, in the conviction that the past is either well known or not worth knowing. Much of college education is a mishmash of unconnected courses. Elimination of a core curriculum has left many students ignorant of their own civilization or of the civilization of which their university is a part, and has left them ignorant of other civilizations. It's also deprived students of a common fund of knowledge that would enable them to more effectively articulate their disagreements as well as their agreements. The hollowed curriculum is also politicized, as much by the conservative perspectives it routinely excludes as by the progressive doctrines it aggressively promulgates. Worse still, higher education fails to teach the truly liberal principles that explain why study of both conservative and progressive ideas nourishes the virtues of toleration and civility so essential to liberal democracy's well-being. What should be done? Again, incorporate into freshman orientation programs on the purposes of liberal education. The curriculum should not only introduce students to the humanities, the social sciences, and the sciences. There should also be a mandatory course on the tradition of freedom that undergirds and inspires both liberal education and the American constitutional order. In addition, the curriculum should require study of the great moral, political, and religious questions and the seminal and conflicting answers that mark the West. And the curriculum should require study of the seminal and conflicting answers to those great questions put forward by some non-Western civilization. In conclusion, to provide a properly liberal education, colleges and universities must undertake three sorts of reforms. First, they must institutionalize the unfettered exchange of ideas. Second, they must govern campus life on the premise that all students are endowed with equal rights, and so equally deserving, regardless of race, class, or gender, of due process. And third, colleges and universities should renovate the curriculum so that it introduces all students to the principles of freedom, so that it introduces all students to the continuities, cleavages, and controversies that mark America and the West, and so that it introduces all students to the continuities, cleavages, and controversies that mark at least one non-Western civilization. To accomplish these reforms, the conceit of infallibility must be tamed. Progress in any one reform depends on progress in all three. But to recall a matter that Marx touched on and that Plato pursued, who will educate the educators? 35 years ago, a brilliant young Harvard Law School professor named Roberto Unger published a remarkable essay in the Harvard Law Review. A manifesto of sorts, the essay is called, The Critical Legal Studies Movement. Unger ruefully described the academy he had recently entered. He likened his fellow professors to priests who had lost their faith but kept their jobs. Times have changed. The academy has undergone a kind of religious awakening. These days, many professors resemble priests who believe that their job is to impose their faith. But the zealous priest is no more suited to the vocation of liberal education or legal education than is the cynical priest. Professors would do better to take midwives as their model. Liberal education's task is to liberate and emancipate. Liberate from ignorance, emancipate from dogma, so students can live examined lives. It does this by furnishing and refining minds, that is, transmitting knowledge and equipping students to think for themselves. But what about political responsibility? What about justice? What about saving the country and the world? Through the discipline of liberal education, professors do what is in their limited power to cultivate citizens capable of self-government. And law professors do what is in their limited power to cultivate thoughtful lawyers. These are lofty accomplishments. These are lofty contributions, and self-government and the rule of law are essential features of liberal democracy, the regime most compatible with our freedom, our equality, and our natural desire to understand the world and to live rightly and well in it. Thank you very much. Questions?
So Professor Berkowitz has agreed to answer some questions. Also, he will be available from 4 to 5:30 this afternoon in WCC 5051 to meet with students who have further questions. I think we have time for a couple of questions right now. Great. Please.
Thank you very much for your remarks. I'd like to challenge two parts of your comments about freedom of expression on campus. First, you expressed your support of the law in California that imposes on private colleges the federal constitutional regime that's appropriate to public colleges. My question is, it seems to me that that's anti-pluralistic. Why empower the government to impose the same standard on public universities as private universities? Just suppose a group of people want to get together and have, let's say Ayn Rand University, and they say that, socialists are not welcome on campus. In a huge society like ours, a pluralistic society like ours, why not let 1,000 flowers bloom? That's one. Second, you talked about the instances in which people object to speakers, and or not just to speakers or to somebody giving a commencement address. This has been commented on a lot, and this is viewed often, and you spoke of it, as censorship. Why is that censorship? If Harvard University invited the, some Taliban leader to give the commencement address, and then I got together with students and we complained about it and asked the administration to reconsider the invitation, we would simply be using our rights of freedom of expression to ask the administration to reconsider its views. And if they did reconsider their views and rescinded the invitation, why isn't that just an instance of deliberation in which people reconsider a view that they once had? Those are my two objections.
Fair enough. Take the second one first. I agree with your example. However, what has been happening in recent years is that Condoleezza Rice, Robert Zoellick, Ayaan Hirsi Ali have been disinvited as a result of invitations. And I reject the comparison of those people to the Taliban. I have to accept in principle your point. Yes, if Harvard University went so far as to invite a leader of the Taliban dressed, I'd have to think about it. I might join you in protesting. So, yes, I can imagine circumstances. But maybe I'll put the matter this way then. It seems to me that right has been abused in recent years. As far as your first point, another good point in theory, it seems to me right. We live in a pluralistic country. Let's allow 1,000 institutions to bloom. But it doesn't seem to me that the state governments or federal governments have an equal interest in providing tax breaks and other kinds of financial support for all kinds of universities. It seems to me that state governments and the federal government has a special interest in supporting through massive tax breaks, through federal funding of research, through student loans and other ways. It seems to me government does have an interest in supporting colleges and universities devoted to liberal education. So yes, I would be in favor of a private university that doesn't receive federal or state funding going about its way restricting speech as you suggest.
Hi, thank you for sharing. I feel like there was a bit of internal inconsistency with respect to your third reform. Wouldn't the shrinking or even the elimination of a core curriculum actually promote freedom?
No. In the same sense that eliminating training, discipline, and learning in learning jazz music would not promote the ability to improvise in a complicated piece. To improvise in a complicated piece, one needs to be a master. One has to go through training. One has to learn a lot. And it seems to me that freedom, real freedom, is an achievement, and that achievement is enabled by acquiring a solid foundation of learning, which then allows students to improvise. Here, it's coming.
So, thank you again. My question is two-parter. The first part is, do you believe that the project of liberal education remains a possibility in a climate where the vast majority of traditionally liberal colleges seem to have been increasingly dominated by professors who openly reject liberalism, espouse various theories of critical analyses that pretty much undermine the entire liberal idea? And secondly, which is related, do you believe that professors of any discipline have a moral and ethical obligation to expose their students to a wide variety of materials from different perspectives, instead of using academic freedom as a shield to say, I can, impose my perspective on students who have no previous exposure to a given topic? Thank you.
Thank you. Well, of course, I agree with the second point. I think it is the pedagogical responsibility of professors to expose students to the best arguments on, I was about to say both, but I should say the several sides of questions. I recognize that as a practical matter, one can't do everything in class. As a practical matter, one comes in with one's prejudices and biases. Sometimes as part of the curriculum, a class which focuses on one view actually serves as a counter-argument to many other classes. But in principle, it seems to me that yes, it is the task of liberal education to expose students to transmit knowledge and expose students to the arguments. Yes. On your first point, yes, I do worry that the situation is grim. Therefore, I think those of us who are concerned about liberal education, both because of its inherent benefits and because we believe that liberal education, that illiberal education actually contributes to polarization, and because we believe that liberal education tempers extremism, we have an obligation to do what's in our power to continue to fight for liberal education. But yes, sure, I'm worried.
That's all we have time for. Thank you very much.
Thanks.